I think we're all working off the updated electronic bundle of the 30th of June.
My Lord, yes.
Yes, thank you. Page
1355, and the committee should arrive at, or be at, a speech which was given on the 1st of October of 2019. And in considering this document, I ask, please, that this sequence of events be borne in mind. This speech was made on the 1st of October 2019. Dissolution of Parliament followed on the 6th of October 2019. The manifesto upon which reliance has been placed in defence of the charge of bribery was issued on the 23rd of October 2019, and the election took place, the poll took place on the 7th of November 2019. The committee will have had a chance to look at and to read through Section 64 of the Representation of the People Act, which is the provision as far as bribery is concerned. And in looking at this speech, as we're about to do, it is as well to have in mind, I respectfully suggest, that provision, Section 64, refers to any person who directly or indirectly, by himself or by another, promises to procure or to endeavour to procure any valuable consideration to induce a vote.
Is normal electoral campaigning, does it fall foul of Section 64?
Normal electoral campaigning doesn't fall foul of Section 64, no.
Okay. And then what is the distinction between normal electoral campaigning, where you say, well, we're going to do this in the future, we're going to make available these funds for doing this, and that will benefit, for instance, selling council houses. How do you distinguish between the two?
Well, you distinguish between the two in this very straightforward way, I suggest. You've got your political programme, which contains in your Lordship's instance, the right to buy, the sale of council houses. And so you put that into your manifesto, and as a candidate you say,
there was no quid pro quo or private arrangements between the respondents and the voters of constituency number 8, whereby the latter would have obtained an increase in BRP only if they voted in return of the former. There was no element of bargaining. And the conclusion at the bottom of page 422, this was an electoral promise contained in an election manifesto and made in the course of normal election campaigning. It was no more, no less than a statement of intention of a future eventual government. So those were the findings in relation to the BRP. The findings in relation to the PRB report are at page 427, please.
page
427, please, my lord. And this is on the final paragraph starting in the case of both alliances. And proposals relating to the PRB were contained in their electoral manifestos and made openly in public, addressed to the whole of Mauritius, not just constituency number 8. There would be measures applying to public officers residing in the whole of Mauritius, not just constituency number 8. There were promises of the future government. And then in the second paragraph,
They weren't saying that ordinary normal election proposals fell outside Section 64, but rather they were going through why the inference that it was to induce the electors to vote in a corrupt sense was incorrect. Which do you say it is?
Well, it isn't entirely clear from the judgment which approach the court is adopting.
Which approach is the correct one?
Well, in my submission, ordinary election proposals are out with the scope of Section 64. That's not uniquely by reference to the corrupt purpose point, but one has to look at all the factual earlier question, which is the factors that weighed with the Supreme Court as to why the respondents' statements in this particular election were not bribery, but were in fact normal election campaigning, are in our submission unassailable, and this is what they were.